Welcome to the case summary for Lonergan versus Scolnick on 4lawnotes.com. In this case, the seller of a property placed an ad in the Los Angeles newspaper offering 40 acres in Joshua Tree in California. The plaintiff saw the ad in New York and initiated some correspondence with the seller, discussing things like price and characteristics of the property. They had multiple exchanges back and forth, and finally the seller of the property wrote to the plaintiff and said, "Look, you better decide quickly. I expect to have a buyer." And sure enough, after sending the letter, the defendant seller sold the property to another party. But when the plaintiff received the defendant seller's letter, he immediately opened an escrow account, sent a check and a letter to the defendant accepting the offer, and said, "Please send the title to this escrow account." The issue in this case is whether or not the correspondence exchange that they had constituted a meeting of the minds that would amount to an offer and an acceptance. And so the holding in this case established the meeting of the minds standard for contract law, that there can be no contract unless the minds of the parties have met and mutually agreed. So the holding was for the defendant that there was no offer and acceptance, and the court cited Section 25 of the Restatement of Contracts that if the person to whom the promise or manifestation is addressed knows or has reason to know that the person making it does not intend it as an expression of his fixed purpose until he has given a further expression of assent, he has not made an offer. And that concludes this case summary for Lonergan versus Scolnick on 4lawnotes.com.